We are here in State of Indiana versus Richard Allen, 08C01-2210 MR1. Show that the defendant is here in person with Mr. Baldwin, Mr. Rossi, and I'm sorry, I don't know the lady at your table.
This is Ms. Auger, Jennifer Auger.
Okay. She's the attorney that entered her limited appearance for digital forensics information.
She did, Judge. And then, there was an appearance that was entered a week or so ago that was a general appearance.
And I entered an order on that, and you should be receiving that shortly. It was a confidential order. States.
Would the court, I'm sorry, may I?
No. The states hereby their chief elected prosecutor, Mr. McClelland, Mr. Luttrell, Ms. Diener. Yes, what?
Well, to the extent that it might have an impact on what she can do at the hearing today, I was suggesting maybe we could approach the bench and you could advise us as to the nature of the order, just so that we're not crossing some boundaries that the court's not permitting us to do.
You may approach.
Sidebar conference conducted.
I was not aware of a limit. I granted your motion for an expert. She's the expert, apparently, in digital forensics. The limited appearance was for that very limited issue, and then I see a general appearance. I don't know what that is, and I asked for explanation. I don't have the order, it's not in the file.
Okay.
'Cause it's confidential order, so no, I'm not gonna.
Well, she's not an expert, she's an attorney.
Well, she was listed as an expert in the field of digital forensics in Mr. Rossi, or Mr. Baldwin's request.
Inaudible, funds?
Yeah, for funds.
Oh, yeah,
And I approved that, no, and I approved that. I know she's an attorney and then.
Yeah.
So she entered a limited appearance for that specific purpose and then, all of a sudden, I see a general appearance. I don't know what that is. I haven't authorized a general appearance, I authorized a limited appearance.
I understand that, yeah. I was
So that's
articulating to the court what the posture was to make sure we were on the same page.
I believe that we are. And I don't know what her role in this is going to be. I assume it's limited to the digital issues that you have raised in the past.
Yeah, I think that was the original intent. And then, obviously, because of the workload and the late discovery, which we're continuing to receive, which has just been the natural course of things, we felt like that we didn't want to be penned in when we got into court with her just being able to talk about that limited issue. We basically just, asked the court to recognize her as one of the attorneys on the case so that she can.
Well, that's something that
assist us in litigating at this late hour.
Well, then that's something we'll have to discuss, because I haven't approved that.
Sure, that's fine.
I've approved a limited appearance.
I just want to make sure she's not doing something today that you haven't, that you're prohibiting her from doing. That's why I asked.
As long as she's limited to the digital issues then.
Yeah.
I don't have a problem with that. That's what I've approved.
Yeah, I think that the confusion is this, where are the parameters in that sphere also? Because those are terms of art, and we've learned all that in the last couple weeks as we've, lit, as we've done some discovery in this field. So, those are just some of the things. We can talk about it when we're finished today. I'm fine with that.
Okay.
Okay. Very good. Thank you.
Thank you, Judge.
Sidebar conference concluded.
All right. The defendant filed a motion for pre-trial hearing on April 30th th. I set that for hearing today so that we could discuss the issues that you've raised. And before you get into that, earlier this morning, Deputy Attorney General Aaron Ridlin appeared on behalf of the Department of Correction. The Department of Correction is a non-party and the defense filed a motion to enter a stipulated protective order. I granted that motion and sent the order to the clerk of the court on May 2nd ND. For reasons that I do not understand, the clerk of the court never entered it as an actual order of this court and the Deputy Attorney General appeared. I provided him a copy of the order. I've had my staff go ahead and enter that order and it was previously scanned in. I don't know why it didn't go in, but I had my staff then go ahead and enter that order, it's dated May 2nd. It was entered into the CCS on May 7th. I provided a copy of that to counsel on your tables. So I don't know what the disconnect was, but I did grant that.
Judge, I spoke to Mr. Ridlin in the hallway, and he departed the courthouse 'cause he felt like his business was finished today. So I think we're all on the same page about what we were trying to accomplish.
Okay. So then you'll get a duplicate copy of the order, then. Are you ready to proceed on your motion, Mr. Rossi?
Judge, I am. May I inquire as to are we dealing with a request regarding the scheduling issues, or are we dealing with a request or joinder for a hearing on the state's motion in limine?
Both.
Okay. Well, I guess it's the defense's view that if we're gonna address the state's motion in limine, it's their motion, and so they would have the burden of proof to introduce what evidence they need to do to, make their arguments that the evidence should be limited, and then we would respond to that.
So you filed a motion for a pretrial hearing, but you do not wish to have a pretrial hearing?
I filed a motion consenting to the state's request for a hearing on the motion in limine.
Okay. So the motion for a pretrial hearing that you filed April 30th you requested a pre-trial hearing to discuss scheduling issues associated with the trial, secure the appropriate amount of trial time for Defendant Allen to present a full and comprehensive defense, and to address any other pretrial matters that may be necessary.
Very good. I can comment on that.
Okay. Go ahead.
Judge, obviously, we're looking at the trial calendar, and, the court had communicated with parties through an email indicating that this trial was gonna commence on May 13th here in Fort Wayne, and that this trial was gonna end on May 31st in Carroll County. And those dates, in my interpretation of the email, I think you used the phrase, not more or less. They're not flexible dates, those were firm dates that were gonna be adhered to in this case. And naturally, I understand that the court has not been a party to the exchange of the actual witness and exhibit lists because of the way the state and the defense has chosen to communicate. We filed notices that those witness lists were exchanged, but we did not share those with the court, so that they would not become public, at least on our side. And so I understand that the court may not have a full grasp in terms of the context of the number of witnesses that will be called and the amount of exhibits that would be introduced. With that being said, I think I shared with the court in the motion that, that I haven't counted them up to date, but I would say that each witness list, at TH's point, has over 100 witnesses. And that's, probably half of those are duplicated, the other half are not. In the normal course of a trial, I would expect that, only a percentage of those would be called. And so I don't expect the court's gonna see 200 witnesses starting next week, but it's pretty obvious to me that the volume of witnesses and exhibits, at least in the opinion of the defense, would require, substantially more time than the 2.5 weeks that's set aside to present evidence. And with the defense going second, that puts us at a disadvantage, obviously, because we don't know how long it's gonna take for the state's case. And so we've got this problem of, okay, if you're gonna limit the time that we have to introduce and put on evidence, are you going to split that time in half? Is there gonna be some manner in which the court divvies up that time so that there's some equity in the process? I just, practically, don't think that we can do this in that short of a period of time, and that's even taking into consideration that we're gonna be working on Saturdays, and maybe into the evening hours a little longer. I don't want to be in a situation where for 2 or 3 or 4 weeks, or 2.5 weeks, we're sitting here and we're staring at the clock every minute. And so I'm looking for a practical solution to that. I think the defense is looking for a practical solution. I haven't had any conversations with Mr. McClelland about how long he thinks that it will take to present his case, but I feel like we both have a pretty good idea of the scope of the presentations, and I just don't see that we're gonna be able to do it in that time frame. In terms of the law that's applicable, I did lay some of that out for the court. I don't really feel like I need to sit here and make legal arguments. To me, it's more of it's a housekeeping or a business-related matter in terms of how much time the parties would need to present their cases adequately, but to the extent that the law is applicable, it seems to be pretty clear to me that one of the burdens placed on the court is that the court, before issuing any kind of, I'll call them restraining-type orders or orders of restraint, where you're setting specific time frames, that the court must be fully aware of the scope of the evidence that's going to be presented and the witnesses that may be called. And that's based mostly in federal law that has trickled down to the state, because that's where you get most of the regulation regarding the length of trials, and the presentation of evidence is in the federal courts. But that law is out there. And I'm not sure whether it's just, I think in this case, just because of the nature of the communications between the parties, which we all acknowledge are, not the most streamlined, at least I acknowledge that, and that's just the way it is, and that's fine, but we haven't had a lot of dialogue about what's ahead. We haven't had a lot of pre-trial hearings in terms of motions in limine and things like that, and so I understand that the court doesn't have a really good grasp. At least I feel like the court doesn't have a good grasp on the scope of the evidence, and so I think it's a little premature to set firm dates without the court having a better understanding of what would be offered up. I think in September or October, we had a phone conversation, and I believe, during that phone conversation, we were discussing the January 2024 trial date at that time, and I believe the court inquired to the defense as to what we were thinking in terms of time as far as the trial is concerned, and I believe I'm the one who actually suggested it probably would take us approximately 2 weeks, more or less, to present our case. I still think that's basically true. The words, more or less, matter a lot in cases like this when you've got jurors that could be sequestered for long periods of time. You're moving staffs from one jurisdiction to the other. I understand there's a lot of logistical challenges that are on the court, but I still feel like our position hasn't changed. It's probably gonna take us a couple weeks to present our case. And obviously, with the May 13th through May 31st ST trial setting, with part of that being consumed by jury inst or voir dire, it just doesn't provide us with the adequate amount of time to present our case. And I'm opining that the state probably is gonna feel the same way, but Mr. McClelland and his staff can speak for themselves. So we're just looking for some practical solutions to those problems, and that was the purpose for the order, and so that's defense's position.
Mr. McClelland.
Judge, we have done what we can to streamline our witnesses and exhibits that we plan to introduce. I'm not real sure how to respond. The state doesn't have any objection to the 2 weeks. The state hopes to have its evidence done and concluded by the 25th. That still leaves a whole nother week for the defense to present any evidence and any rebuttal evidence. That's our best guess with what we've got. Again, we've tried to streamline it. We've got it down to about 40 to 45 witnesses, and a handful of those, it's a half a dozen to a dozen, would be chain of custody type witnesses. We're trying to work through some of those issues with the defense in terms of stipulations and whatnot, but that's where the STAT's at. The state's satisfied with the amount of time the court set aside. That's the only comments I have, Judge.
So what is your request, Mr. Razi? You're indicating I set this matter at your request for speedy trial. You made your request March 6th. On March 7th I set it for trial May 13th to May 31st st, and the first time I'm hearing that specific dates are not adequate is April 30th in your filing.
Yeah. The defense's request is that the court not book in the back end of this trial to end on a certain date, that being May 31st, that the court understand that the presentation of evidence is just part of what professionals do in a case like this, and that occurs in a natural situation and a natural setting, and it ends when it ends. And to the extent that there is a need to, regulate those time frames in a more strict sense, that we would sit down and maybe the court even consider requesting some, or issuing an order that might further define the witnesses, now that we're getting closer to the trial setting and the discovery is getting closer to being completed, and then make a decision after you've, Mr. McClelland, for the first time today, for example, just suggested he thought they had about 40 witnesses. Well, that's, 30 to 40% of the witness list that we received, so that's an indication of how fluid this case is, and so I would ask that the court either consider some further discussions with the parties to further defy any of those witness lists at the end of the week. But at the end of the day, it seems like we're kind of at their mercy in terms of how long it's going to take them to present evidence, and there's also rebuttal evidence that has to be taken into consideration as well. I think those things are not overly predictable, especially in a case like this. We've got logistics in terms of getting experts to and from. Those will cause, I'm guessing, some further delays. And so what I'm asking the court to do is not set an end date for this trial and understand that it's gonna take more time. I would ask that the defense be given 15 days of actual trial time to present its case. 15 working days would be the request by defense, and some of that's based on our predictions back in September and October of 2023, and having seen the witness list being modified over the last couple weeks because, frankly, discovery continues to come in, and that's just the nature of this case. We're taking depots tomorrow. And it is true, Mr. McClellan mentioned that there's some stipulations that we're working on. Ms. Diener and I have been communicating in that regard to try and streamline some things so that we're more efficient. But at the end of the day, I think that we're gonna need probably 15 days of courtroom time to put our case on. That's what I'm asking the court to consider and grant.
Well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summonses to the jury YTH the dates of the trial. The specialized questionnaire that you all approved some months ago was mailed to the jurors, and you now have copies of those, hard copies, at your request. You all came up and picked those completed questionnaires up. Jury Rule 4 requires that I issue summons to jurors with the dates. Particularly in this matter, the dates that I provided to the jury is May 13th to May 31st. Jurors have been asked to arrange their schedules accordingly around those dates and times, and the rule requires that I mail the summons to them at least a week in advance. I confirmed with the jury office that the summonses were mailed to your venire on April 19th, which was a Friday, and I anticipate that they started getting those summonses to appear on April 22nd ND. So I've given the jury the dates that the trial has been scheduled for, and again, until now, I've not been told that you need this amount of time. I can't bookend a trial when I've already told the jury this is what the dates are going to be. You have a remedy and, again, I wish you would have informed the court well before April 30th that you didn't feel that the dates that were select D at your request for a speedy trial were adequate.
May I?
Of course.
Judge, I appreciate that. This was a situation too where, frankly, the court never inquired with the parties about, what was forthcoming. That request wasn't made that I'm aware of. And I think that might have helped solve some of these problems. But let's just pose the hypothetical. What if Mr. McClelland and the state's case runs into the 28th or 29th of this trial? So is the court gonna allow us 2 days to put on witnesses? And then we walk in one morning on the 31 ST and you say, "Hey, at noon, if you're not done, we're done." We all know that that's gonna pose a problem that's gonna end up causing this Cassie to be retried. There's no doubt about it. There's got to be some flexibility on the back end of this to kind roll with the punches, so to speak, understanding that there are a lot of moving parts here. So I think, under the court's current order, we're at the beck and call of the state. In fact, from a strategic standpoint, you've invited them to put on a more verbose case, which might otherwise chew up our time and not permit Mr. Allen to, offer up an adequate defense. So how are we supposed to deal with that? I mean, I think it's just practically a problem. And I think it violates his Sixth Amendment right to come in here and offer up to the jury a full, adequate, competent, and complete defense, and we're asking the court to reconsider the request for 15 days on our watch. Again, I said this back in September or October. I didn't say 2 weeks for a trial, I said 2 weeks for the defense's case, and I think you even suggested or mentioned that in the email or one of the orders that was issued. And so that's what I said, that's what we're asking for. I think our request is consistent with what we did, what we requested in the fall, and I'm asking the court to reconsider any thought to putting a drop-dead date on when this trial's gonna end.
Well, then you need new trial dates, gentlemen and ladies. That's your solution. I cannot ask jurors that I've already tied in from May 13th to May 31st ST to extend indefinitely or for another or 2 weeks after that timeframe. Again, had you informed the court immediately upon receipt of the motion where I granted your motion for an early trial, had you notified me immediately, Judge, these are not sufficient dates, I would have absolutely given you whatever time you needed on the court's calendar. I have no problem with that. I've tried hundreds and hundreds and hundreds of jury trials, I have no problem at all with that. In my belief, 2.5, 3 weeks, 3 weeks for trial was adequate. I'm now being told 3 weeks is not adequate. I have in my hand the April 30th 2024, Defendant's Notice of Submission of Supplemental Witness and Exhibit List to the State. It's one paragraph, it's a not ice to the court that you're exchanging witness lists. I have no idea what you're doing. That's not my job to know what you're doing, that's not my job to micromanage attorneys. My job is to call the balls and the strikes during the jury trial and to conduct an appropriate opportunity for the state to present its evidence and for the defense to present its evidence. Again, had you told me when you got the order granting your motion for a speedy trial that this is not sufficient time, I would have absolutely given you however many more weeks you were asking for. I hear nothing from counsel, nothing at all from either side, until April 30th your motion for a pre-trial hearing, that this inadequate time and now you're asking me to do something I cannot do. Under the jury rules, I cannot give you that extra additional 15 days at the end of the trial, I can't do it.
So is the court gonna divvy up the time equally? The time that does exist?
The court is gonna ask you all to be professionals, and stipulate to what you can stipulate to. If you're telling me that you're stipulating, I don't know what chain of custody issues have been arising between the parties, I have no idea what that is. Again, you've been very closed-mouthed with the court about what your evidence is, other than the motions to suppress, the multiple Franks motions that you have filed, and the state's responses thereto. I get notice of submission, which is one paragraph that lists no information for the court.
May I?
Sure.
There is the pause. The court has sent out, I think, and produced roughly 450 jury questionnaires. My assumption is that we're gonna voir dire in panels of about 50 at a time. I think I south what the court suggested roughly in some of its instructions. One of the things that the court could consider doing is questioning the jurors, as part of the voir dire, about whether or not they're able to spend more time sequestered to make sure that we can get this trial done, that might be an option. And to the extent that the jurors are not able to extend their calendars or their schedules beyond that May 31st date, then maybe they would be struck. I think 450 jurors is gonna be more than enough, and I think we can find, in that pool, people that are willing to stay and serve the interests of justice and their civic duties without burden, so that might be one possibility in resolving this circumstance. I'm still not sure, even under the current schedule regime, or regiment, I should say, I'm not sure that I'm aware of how we would present our case, again, if our time is consumed. You're not telling me how we're gonna solve that problem if the state's case takes longer than what they haven't even told you how long it's gonna take except for, well, it might be a week, we're not really sure.
Well, he's indicated 45 witnesses approximately.
Judge, yeah, what the state did is we took the time the court set aside for the trial and we tried to, I guess I'm going to use slang terms a little, we tried to cut the fat as much as we could and streamline this in the most efficient way we could. Now, can't predict what's going to happen and how long the testimony of EACH witness is going to be. We've tried to predict that and we tried to fashion our questions and our witnesses, again, in the most streamlined way possible, knowing that we were set in that allotted amount of time, and so we've cut witnesses in that respect in order to present our case as efficiently as we can. And so that's what we've done, Judge, and I believe we're around 40 to 45. That may be reduced depending on what we can stipulate to. We may have to throw a witness in there if we can't make some stipulations. But we've done our very best to, again, cut as many witnesses as possible while still meeting our burden, Judge.
So your suggestion, Mr. Razi, is to proceed forward and hope that the jurors that we have summoned can give another 3 weeks. Which means the court has made arrangements for the jurors for lodging, transportation, etc. You're asking me then to extend that. What if I can't? I've entered into contracts with vendors.
Well, it sounds like the court just invited me to move to continue the case to another date that that's the way I interpreted what you just said a few minutes ago, which would kind of run afoul or run in the face of you having all these things organized. I understand that. Like that's why we're here having this professional discussion about time. But you're not hearing anything from the state that's suggesting that it's gonna take them a week. He's saying, we're trying to streamline things. Well, that's not real comforting when you're sitting over here and you're on the receiving end of that, So I am not hearing anything from the courts that's confining the state to any specific amount of time. In fact, it's almost like you're not willing to do that in the context of this, which suggests to me that they can sit there and put on evidence until the cows come home. And I don't want to be in this situation where we just stop one day and we tell everybody to go home and we'll see you again in the fall. We're gonna do it all over again. It just doesn't make any sense to me. And I've never been involved in a situation ever, and I understand this is a unique circumstance. But I've never been involved in a situation where a judge set an end date, and not only said it's not gonna end sooner or later.
Excuse me, you've never had a court set a trial date for you, is?
I've had a court set.
That what you're telling me?
Starting dates, but I've never had a court tell us, it's gonna end on May 31st, no more, no less. Those were the words of the court in this case. I've never had that happen, which is one of the reasons why I filed the motion. And look, we're practicing in different areas of the state. Doesn't mean that what goes on up here is, better or worse than what goes on where I make a living, but that's the reality. That's a
shocking reality, Mr. Razi. I've never heard any of my colleagues give open dates for trials. I'm surprised that happens routinely across the state of Indiana.
Well,
Because in this court and in my experience with my colleagues, you get a trial date. Here's your trial dates, May 13th to May 31st, period.
Yeah, well,
So your experience is vastly different than this court's.
And that's fine. The problem is we have to deal with those things and find some solutions, and I'm asking the court, in this case, to recognize his right to put on a defense is just as important, and frankly, more paramount, than their right to prosecute.
I don't disagree. And again, I wish you'd have let me know.
And so by pitting us in, it almost seems like, I used the word invite earlier, it seems like you're inviting them to make his situation, Mr. Allen's, more untenable, and I don't understand that. I don't understand how it is that the court couldn't reach out to the parties before the court issued the order setting the dates and saying, hey, I'm getting ready to issue an order setting dates. 2 weeks gonna be enough? 3 weeks gonna be enough? A month? I mean, a lot has occurred since September and October when we talked, and so, it seems like to me that, why that didn't happen, I don't really care. I know that we're dealing with that circumstance as we're sitting here today. I just want to get the problem fixed, and that's
Well, it happened, sir.
for the court to consider.
Because I don't feel, if I email, my emails end up in pleadings. Obviously, we can't have a 6-way phone conversation, and emails ending up in pleadings is not how I do business, so I do business in written orders. I gave you an order granting your motion. You're now telling me it's insufficient. Again, I don't know what you want me to do. I gave you set trial dates. I've always given you set trial dates. You've never indicated that those dates were inadequate, again, until April 30th, when we sit here now today, so.
Can we have a 5-minute recess, please?
Why?
I would like to speak with my co-counsel here and have a discussion about the business issues such as scheduling, not here in a courtroom where everybody's listening to us. We've got, 50 staff members in this courtroom, people sitting behind. There's no privacy, and I'd like to talk to him in the hallway about some of the logistics of this so we can solve this problem so that he, Mr. Allen, can put on a defense.
Does the state have any objection to a recess?
No, Your Honor.
All right. Jody, you can go off the record.
Off record at 9:32 a.m. On record at 9:42 a.m.
All right. Have you had adequate time, Mr. Rossi,
Yes, ma'am.
to have some discussions?
Yes, ma'am.
Okay. I note in your motion for a pre-trial hearing, as well, that you had indicated in your paragraph 15 that this case doesn't present itself to the court as a case of first impression, at least not from a scheduling standpoint, and you are correct in that. I did preside over the case of State of Indiana versus Bob Leonard, which was a case venued from Indianapolis, Marion County, in 2016. I think it was commonly known down in Indianapolis as the Richmond Hills explosion case. That case was set for trial, you are correct, for 34 days, with nearly 140 witnesses. What you didn't include in your petition and your pleading is that that case was actually tried by this court in 20 days with 161 witnesses and over 2,000 items of evidence. I also tried State of Indiana versus Cohen-Hanch-Barron, a life without parole with an individual who murdered his girlfriend and her 3 children. We tried that in 7 days with 36 witnesses and over 200 items of evidence. Bryce Pope was a life without parole case that I tried in 4 days with 2 victims. Dustin Neal was a 2017 murder that was tried in 2023, and I tried that in 4 days. And I tried a death penalty case earlier in my career in 2.5 weeks with 4 victims. So I am experienced in scheduling matters for trial, gentleman and lady. Again, I've given you the opportunity to consult with counsel and co-counsel to kind of see where you're at and to speak with Mr. Allen. What would you like to do, sir?
Judge, first things first, I'd like to just make a record that we did have a chance to speak with Mr. Allen in the jury room.
Okay.
and I appreciate it. Some sense of privacy in that regard. I would like to note for the record that we have security staff standing next to us when we're talking to him. We're not permitted to talk to him in private. There are 2 gentlemen in there. I'm sure nice gentlemen, sure doing their job. But the idea that there's any confidences that are communicated to our client in this case. It's not true, and that hasn't been the case throughout. It wasn't the case a few minutes ago when we walked in that jury room and had people, essentially, standing next to us when we're talking. The same was true when I was here a few weeks back, a month or so ago, when we were out in the hall. We were offered up a spot in the corner of the hallway to talk to our client, while the security staff stood any RB. And I'm asking the court to consider in the future to allow us to spend our time with some form of privacy. I would appreciate that. Sergeant Jeremy Tinkle. We can certainly take him down to our office, and they can talk to him while he's in the holding cell.
Can we do that? SGT Tinkle, yes, we can. Okay. You can do that right now if you want. Speak to him privately.
Well, it's too late. We just had this conversation, knowing that we had limited time and I didn't want the court to. We knew we had to get back in here. I asked for 5 minutes, so...
Sergeant Tinkle has informed me that you may speak with your client privately down in their offices.
That ship has passed, okay? I appreciate the offer, but it doesn't make any sense for us to go back in there and talk about what we just talked about. I'm asking the court to consider, moving forward, that we be given some privacy with our client. Second, what we're requesting from the court today is 15 business days to present our defense.
Okay.
15 business days. We believe that that's the amount of time it would take us to present an adequate defense on Mr. Allen's behalf. Third, to the extent the court is inclined to deny that request, then we are asking that we're moving to lift our speedy trial request and we're asking the court to give us a new date in earnest, when the court can set aside the adequate time that we've requested to present our case. What the state does, that's on them. They can ask for however much time they need, but we're asking for 15 days.
Mr. McClelland? I'm sorry, were you done?
I am finished. Mr. Baldwin would like to speak.
Judge, we are filing a second request for you to be disqualified in this case. I have that here. It will be filed by email, as well as, or by filing. May I approach?
What do you have?
A motion to disqualify you as judge on this case.
Oh, okay. It needs to be e-filed.
Okay. Would you like a paper copy?
No, I can get one when it's e-filed.
Okay.
I have nothing further.
Mr. McClelland?
Judge, in terms of response to defendant's motion, I guess I'll just focus on the lifting of the speedy trial setting and trial date. Judge, we'd leave that discretion to the court. Of course it's frustrating, we're ready to go on the 13th, we're ready to move forward. But I would leave that part to the discretion of the court. In terms of the defense's second verified motion to disqualify, Judge, it's 24 pages, Judge. I haven't read through it, I don't have any response to it at this point, and so I just leave it at that, Judge.
Well, he hasn't e-filed it, so when it gets e-filed, you'll have the opportunity to file your appropriate response.
Thank you, Judge.
So you're waiving your right to a speedy trial, then?
Yes, at this moment we are.
Okay. And you're asking for 15 business days. I've looked at my calendars, and we were originally set in Carroll County October 14th through the 31st. If you are requesting an additional 3 weeks after that, we can go October 14th to November 15th.
Is the court granting a request for 15 days for the defense to put on its case through within that time frame?
If you can't try this case in a month, gentleman and lady, there's something wrong. I see no reason that this case cannot be tried in 30 days. We will work on Saturday, the schedule that I previously provided to you in an email some month ago. I see no reason that it can't happen in that timeframe.
You don't know anything about this case. With all due respect, Your Honor, you haven't seen a witness list or an exhibit list.
No, I have not.
So I have no idea how you can have any context for what is involved in this case. And the discovery continues to come in, because every day that he sits in that hole down in Wabash Valley, there's new evidence that's presented.
So are you.
By way of 24 hours of video, camcorder video, medical records, psychiatric records. How would you possibly know? We haven't had a pre-trial hearing on any substantive issue in this case. You have summarily denied everything we've put on your desk. How would you possibly know how long this case is going to take to try it? It's beyond me. I don't understand how that could possibly be.
I have 27 years of experience on the bench, Mr. Rossi, trying multiple high-profile homicide, life without parole, and death penalty cases. Are you telling me that 30 days is inadequate for the state and the defense to try this case?
I'm telling you that picking an arbitrary number does not make sense. What makes sense is having the parties have discussions, maybe in an open court with a scheduling hearing that would be ordered, about really how many witnesses are coming, really how many exhibits are you putting in, what are your logistical challenges, those kinds of things, and then we can come to some conclusion on how much time it's gonna take.
Well, then why don't you have those discussions and then let me know that you cannot physically do it in 30 days? I'm waiting.
Because we're not talking. It's probably pretty obvious at this point.
Oh, it is patently clear.
Yeah.
To me, Mr. Rossi, that the defense team and the prosecution team are dealing with each other in written form only.
Email only is the instruction we've been given from the state. And so the line of communication is somewhat broken in some, to the extent that those problems could be solved. They could be solved by ordering the parties into a courtroom to have constructive conversations about scheduling, which did not occur.
Well, we're all here now, why don't we have those discussions?
Well, we have been and they're not bearing any fruit. We've made our request, 15 days to try this case. We're moving to lift the speedy trial motion. My simple request is, how much time between October 14th and November 15th will be dedicated to the state's, or the defense's case? That's what I'm asking.
Mr. McClelland.
Judge, I can't give you a definite day of how long it'll take us to present the case. The burden is on us. When I presented to the court before that we would be done by the 26th, that was taking into consideration the time the court had set aside for the trial, and that's only taking into consideration how long we think it'll take to do direct examination of the witnesses. No idea how long it'll take for cross-examination, no idea how much cross is going to be allowed, frankly. And so I'm not willing, from the state's perspective, to say, okay, Judge, give us this amount of days to put on our case. What I can present to the court, what I wanted to tell the court is that we are going to present our case in the most efficient, fast way we can with the time allotted from the court. It is not our intention to take the time given by the court and take up every single day so the defense doesn't have an opportunity to present their case. However, we have the burden, but we are going to take the time the court gives us and do what we can to make it as efficient as possible, not only for the state, for the jurors, for the witnesses that are involved. We're going to do our best, Judge, but I'm not willing to sit here today and say, give me 7 days, give me 8 days. That's just not something I can do, Judge, because I don't know the extent of the cross-examination of the witnesses.
So, Mr. Rossi, Mr. Baldwin, I will grant your motion to continue the jury trial and order it reset to October 14th through the 15th at 8:30. Beginning at 9 o'clock every morning down in the Carroll Circuit Court. Show that you've withdrawn your right for a speedy trial. While you're all here, Do you wish to schedule a pretrial hearing or do you want to address we can set pretrial hearings. And, Mr. Rozzi and Mr. Baldwin, when the court summarily denies motions that have been filed, it is the court's belief that there's nothing within the pleadings that have been filed that require a hearing. So if you wish to have a hearing on your various motions to suppress, I would entertain that. When would you like that set?
Judge, while Tiheri looking at their calendar, I'm sorry, Judge. There was some rustling in the background, I didn't hear the dates. October 15th through when for the trial date?
October 14th.
Oh, 14th.
To November 15th.
Okay. Thank you, Judge. Apologize about that.
I believe there are 2, maybe 3, motions to suppress that are still pending. I know one I just got and the state hasn't responded to, so you've got your 10 days to respond.
Judge, I can tell you the plan with I'm sorry, I don't know if it's a 3rd or 4th Frank's motion filed. The state's intent, given that we expected the trial date to start on Monday, was going to rest on the previous responses filed, but...
Okay.
The state will take another look at the most recent motion to suppress filed and then draft a response quickly, Judge.
Whenever the court can get it set, Judge, we can look at our calendars, but whatever works for the court.
We were supposed to be available to the court May 21st through the 23rd, so why don't we set the motions to suppress for then?
Yes.
We'll set aside 3 days for pending motions May 21st through the 23rd, so that can be the motions to suppress. I know there was a second one and I think maybe a third motion to suppress, as well as the state's motion in limine that we can resolve at that time, as well.
So, Judge, is the court referring with the motion to suppress, you're including the Franks? I think there's 2 Franks motions pending and 2 motions to suppress. Any pending motions, basically?
Not the Franks hearings.
Okay.
Not the Franks, just the motions to suppress and the motion in limine.
Okay.
Are there any other pending motions other than the Franks motions that you haven't replied to, Mr. McClelland, that the defense has filed that you want a hearing on?
No, Judge. There's only 1 Franks and I pulled it out. It's the 4th Franks motion the state has not responded to, was going to respond to that orally today given the short trial date. The only other motion, I think there is a motion to compel perhaps filed by this defense. And then last night, late in the evening, Judge, I filed a request for pre-trial ruling on admissibility. I would ask the court to consider hearing that on the 21st through the 23rd as well. I don't think it'll take long, but I would ask the court to consider that as well. It was filed late last night. It may not have been accepted yet by the court.
It has not. It's not in the...
I didn't think it would.
It's not in the file.
It was late last night when I filed it, Judge, so...
What was it? What's it called?
Basically, we want a ruling. We've got some documents we'd like the court to review and rule on their admissibility. There's some pretty important documents to the state. They're incriminating statements made by Mr. Allen, and so we'd like the court to review those. I'd like to give them to the court under seal because they are pretty incriminating, and so I would like the court to consider those and give us a ruling on whether or not they could be admissible at trial. I can refile it with the exhibits sealed or I can present those to the court today under seal. I've not talked to defense about that at this point.
You can just give me the sealed documents, but the motion is, again, it hasn't been accepted yet and, obviously, the defense hasn't seen it.
There's nothing in the motion that needs to be sealed, Judge. I just didn't attach the exhibits to the motion because when I filed it, I wasn't sure the process to make sure they were sealed, and so I just didn't want to file them. But I'd like to present them to the court under seal, so the court can consider those in conjunction with the IC code that we cite so that we can talk about that on the 21st or the 23rd at some point.
Okay. Does the defense have anything else?
Judge, just an inquiry about what's gonna happen with Mr. Allen. His movements and location and housing circumstances are. We're unaware of what those are. What's the court anticipating moving forward? I know he was. I learned in a deposition the other day that he was gonna be brought up here, so I don't know what. So is he gonna be in Tippecanoe County? Is he gonna be here? Is he gonna go back to Pendleton or?
If you really want to have this discussion in front of everybody, I'm happy to do that, but for security reasons, I don't think that's appropriate, Mr. Rossi.
Well, if the court would be inclined to email us and give us,
I'm not emailing any longer because, again, my emails continue to end up in people's pleadings and I don't think that's appropriate. So again, if you would like to have this conversation in front of company, I'm happy to do that, but I don't think it's advisable based on security issues for Mr. Allen's safety.
Okay. We can have that conversation in a setting that's more confidential. I'm okay with that.
Thank you. Anything else from the state?
I don't believe so, Judge.
All right. Then, we'll see you in court, be prepared, and we'll do May 21st through the 23rd for 3 straight days, starting at 9 o'clock and ending at whenever we end, so be prepared.
In Carroll County, Judge?
I'm sorry?
In Carroll County?
In Carroll County. Be prepared on the motions to suppress, the motion in limine, the motion for ruling on admissibility, and that's all I have so far, and the motion to compel, I'm sorry. All right. Thank you very much. Jody, you can go off the record.
Thank you, Judge. This concludes the proceedings at motions hearing conducted May 7, 2024.